Good evening, everyone, and welcome to our Guildford Chambers Private Children's Seminar. My name is Nicola, Holland, and I'm going to be addressing you for the first part of our talk, and my colleague Andrew Austin is going to be dealing with the second. The topics for our talk this evening are going to be domestic abuse first, and then Andrew's going to be dealing with case management cases, and we're going to leave you with a number of other interesting cases that time prevents us from going into in much detail this evening. So without further ado, on to the first topic, domestic abuse, a topic that you all probably have heard quite a lot about this year, including probably the three cases that I'm going to be addressing, the first of which is the case of M and F. This case was has a detailed judgment that was handed down by Mr. Justice Hayden, who made extensive findings of coercive and controlling behaviour. The judgment underlines the need for the court to assess a pattern or series of acts cumulatively. It was decided before the case of Re H&N, which is probably a case that's very familiar to you, but it was considered favourably in that judgment. Now, the background to the case: there were two children aged 6 and 3 years old. They lived with their mother, and the father had applied for contact with them. There had previously been an appeal to the Court of Appeal which overturned a case management decision not to accept similar fact evidence. The case was transferred to the High Court, and that court heard not only about the father's treatment of the mother, but about his treatment of a subsequent partner, Jay. She was a woman in her 40s with 2 children. The mother had managed to extricate herself from the father, but Jay had not been able to do so. The parents of both women and Jay's ex-husband gave evidence to the court about the disturbing extent of the father's controlling behaviour. There were considerable similarities in the father's treatment of both women, who were systematically isolated from their entire networks. The judgment should be read in full to gain a full appreciation of the father's behaviour. There were extensive findings of coercive and controlling behaviour against the father, and the court found him to be a profoundly dangerous young man, dangerous to women he perceives to be vulnerable, and dangerous to children. Given the lack of reported cases dealing with patterns of behaviour, Mr. Justice Hayden considered the definitions in the Family Procedure Rules, Practice Direction 12J, and in Section 76 of the Serious Crime Act. He commented that a tight, overly formulaic analysis may ultimately obfuscate rather than illuminate the behaviour, and that recognition of the insidious scope and manner of this particular type of domestic abuse is essential. The key is to recognise the significance of individual acts may only be understood within the context of wider behaviour. He declined, unfortunately, to give any guidance of the use of Scotch schedules generally, but did comment that such an insidious type of abuse may not be captured by this formulaic approach to marshalling the evidence and honing the allegations. He considered that where coercive and controlling behaviour is alleged, Scotch schedules are ineffective and frequently unsuitable. The next case we're looking at is the case of HN, as I said, one that you're probably very familiar with, but it's worth setting out in some detail. In this case, the Court of Appeal heard 4 appeals, all of which concerned the Children Act 1989 and involved allegations of domestic abuse. The court granted intervenor status to 4 interested parties in anticipation of the importance of the judgment, those being CAFCAS, a group of women's organisations, Families Need Fathers, and the Association of Lawyers for Children. The court gave significant guidance on how the family courts are to deal with allegations of domestic abuse by moving away from focusing on specific allegations to instead focus on the wider context illustrated by patterns of behaviour. And it's right to point out that although the principal focus of the court was on controlling and coercive behaviour, the observations apply equally to all forms of abuse where a pattern of incidents is alleged. The court noted that there were a number of initiatives currently reviewing how domestic abuse allegations are dealt with in private law proceedings. and therefore its focus was limited to offering guidance on those matters which are most directly relevant to the court process. It noted 2 reports that came out during the course of 2020, the first being the Ministry of Justice report assessing risk of harm to children and parents in private law children cases, and the President of the Family Division's Private Law Working Group report. It said that a number of recommendations from the reports were being implemented with regards to the approach in domestic abuse to domestic abuse in private law proceedings, and noted as well that the domestic abuse bill was at that point before Parliament. As a result of all of these initiatives, the court gave limited guidance on a number of matters that commonly arise in the family court, those being whether there should be a fact-finding hearing, the use of Scott schedules, the approach to controlling and coercive behaviour, and the relevance of criminal law concepts in private law proceedings. Turning to the first of those, fact-finding hearings, the court explored Practice Direction 12J and accepted that it remains fit for purpose for the purpose of recognising all forms of domestic abuse and how to approach such allegations. Importantly, none of the submissions to the court had suggested that the current definition of domestic abuse in the Practice Direction required major amendment, and the court also noted that the definition of domestic abuse in the Domestic Abuse Bill before Parliament was substantially the same as that contained within the Practice Direction. The court recognised that difficulties arose in the interpretation and implementation of the Practice Direction, particularly with reference to controlling and coercive behaviour. Paragraph 37 of the judgment sets out the proper approach to deciding if fact-finding is necessary, proportionate and in accordance with the overriding objective. And I've summarised on this slide the 4 parts to that. The first being to consider the nature of the allegations and the extent of their relevance in deciding whether to make a child arrangements order and if so, in what terms. To have in mind the purpose of such a hearing. To consider whether such a hearing is necessary. Is there other evidence? Are the allegations relevant if they are proved? To consider, and lastly, to consider whether a separate fact-finding hearing is necessary and proportionate, keeping in mind both the overriding objective and the President's guidance in the road ahead. In keeping with this approach, the court made abundantly clear that fact findings are only to be used where necessary to ensure that procedural proportionality is maintained at all times, both before and during any fact finding. Now, as an interesting note, CAFCAS emphasised during their submissions that they should have an active involvement prior to the determination of whether or not there should be a fact-finding hearing, rather than the current system of a safeguarding letter, which they said at times constitutes a suboptimal level of involvement. The court gave no judgment on that point, but did recommend that close consideration of the suggestion should be given by those who are in charge with reviewing the Practice Direction. Now, the second element of the judgment was the question of Scott schedules, one that's very relevant to our day-to-day practice, and all agreed, all appellants, parties and interested parties agreed that the use of Scott schedules was problematic. Some even went so far as to describe them as a potential barrier to fairness and good process rather than an aid. The court's primary concern was the need to focus on the wider context of whether there was a pattern of coercive and controlling behaviour, as opposed to a list of specific factual incidents. The secondary concern was the practice of limiting parties to a specific number of allegations, which may be reduced further at future hearings. The court accepted that if a reduced number of allegations was proven, there would be a risk that only the facts that had been established would be used as a basis to accept the perpetrator's future risk, and that this may inhibit the court's ability to view the perpetrator's behaviour as a pattern. The court confirmed the need to move away from using Scott schedules, but unfortunately declined to provide specific guidance as to what should replace them. Instead, it highlighted the Private Law Working Group and the Harm Panel's implementation group, and noted that recommendations may lead to changes to the FPR or to the issuing of fresh guidance through a new Practice Direction. The third area is the question of coercive and controlling behaviour, and the Court of Appeal found that the definition of domestic abuse within the practice direction recognised that coercive and controlling behaviour by one party may cause serious emotional and psychological harm to the other members of the family unit, whether or not there had been an actual episode of violence or sexual abuse. The court did not provide a specific definition of coercive and controlling behaviour, but instead referred to the case that we've already looked at this evening, the case of F and M. The judgment in that case was endorsed by all parties, and the Court of Appeal found those endorsements to be fully justified and cited the central paragraph, which I've outlined on the slide. The nature of the allegations included in support of the application can succinctly and accurately be summarised as involving complaints of coercive and controlling behaviour on the father's part. In the family court, that expression is given no legal definition. In my judgment, it requires none. The term is unambiguous and needs no embellishment. Understanding the scope and ambit of the behaviour, however, requires a recognition that coercion will usually involve a pattern of acts encompassing, for example, assault, intimidation, humiliation, and threats. Controlling behaviour really involves a range of acts designed to render an individual subordinate and to corrode their sense of personal autonomy. Key to both behaviours is an appreciation of a pattern or series of acts, the impact of which must be assessed cumulatively and rarely in isolation. The Court of Appeal found that the judgment was a central reading for the family judiciary and of value both because of the illustration that its facts provide of what is meant by coercive and controlling behaviour, but also because of the valuable exercise that Mr. Justice Hayden had undertaken in highlighting the statutory guidance in Section 76 of the Serious Crime Act, which identified paradigm behaviours of controlling and coercing behaviour. And it said that that guidance is relevant to the evaluation of evidence in the family court. So the court went on to consider the approach to be taken when coercive and controlling behaviour was raised as an issue, and was concerned that consideration of a pattern of such behaviour may mean that courts take longer to get through cases. The guidance it gave is set out between paragraphs 56 and 59, and again, I've summarised that on the slide. So the court said that it's the responsibility of the judge to set a proportionate timetable and maintain control of the process. That if controlling and coercive behaviour is a primary focus, the need to determine date-specific allegations would cease to be necessary unless an allegation was so serious as to justify determination. It said that where fact-finding is necessary, only allegations which are necessary to provide a factual basis for either a report or assessment, for a risk assessment, for the consideration of welfare-based orders, or to consider the need for an activity requirement, only those should be listed for determination. It said that in every case where domestic abuse is alleged, both parties should be asked to describe in short terms, and that was said to be either orally or briefly in writing, to describe their overall experience of the relationship. It said that where coercive and controlling behaviour is alleged and a fact-finding hearing is necessary, the pattern of behaviour should be the primary focus for determination, and that any other factual allegations should be selected for trial because of their potential probative relevance to the alleged pattern of behaviour, unless the allegation was so serious it justified determination irrespective of the alleged pattern, for example, an allegation such as rape. And the final area that was considered within the judgment is the criminal law concepts, and the Court of Appeal noted that criminal matters have a different scope and purpose to family matters, but said that domestic abuse straddles both, and that domestic abuse is capable of being both the subject of prosecution as an offence before the criminal courts and the focus of concerns in the family courts when considering the need for protective orders. The court endorsed the position as outlined in the case of Riar, which held that it was fundamentally wrong for the family court to be drawn into an analysis of factual evidence in proceedings relating to the welfare of children based upon criminal law principles and concepts. The judgment makes clear that a family law judge making a finding on the balance of probabilities is not required to consider whether a criminal offence has been proved to the criminal standard, and says that the court should determine how the parties have behaved and what they did with respect to each other and any children, rather than whether that behaviour comes within the strict definition of a crime. This does not mean, however, that the family court users should shy away from terminology such as rape or similar words used in their ordinary sense. Now, the last case that I'm going to explore with you is the case of AA and BB. This is one of the first cases to be reported post ReHN, and again is an appeal in private or children proceedings, and it concerns a case management decision to exclude evidence from a fact-finding hearing. In this case, both parties were directed to file a Scottish schedule limited to 5 allegations, and their statements were limited to the evidence in respect of those allegations only. No direction was either requested or granted for evidence to be allowed from witnesses. The case was listed for a fact-finding hearing, but unfortunately on the day was not called on until 2 p.m. Counsel for the father raised some preliminary issues when the case was called on, including that the mother's witness statement went beyond the 5 allegations permitted and added more details and examples of the father's alleged abuse towards her and the children. It also exhibited a number of documents, including letters from professionals treating the oldest child, which set out the allegations made by the child against the father. The mother had also sought to rely on witness statements from both the maternal grandmother and the nanny. The judge was asked to exercise case management powers under Rule 22.1 and to exclude the additional evidence. Due to time constraints, the fact-finding hearing was adjourned, unsurprisingly, and the judge limited himself to case management considerations. He largely acceded to the father's request and directed that the mother should file a new witness statement. He excluded documents from professionals, but he did allow the grandmother's statement, albeit commenting that it went beyond the scope of the allegations, and the nanny's witness statement, which was short and general in its allegations that the father had come across as abusive and controlling. The case came before Mrs. Justice Judd, and on the appeal, the mother relied on both the cases we've examined this evening, F and M and ReHN, and asked the court to consider the limitations on the Scottish schedules and the fact that the court had focused on particular allegations rather than looking at patterns of overall behaviour. The judge was sympathetic to the lower court judge, noting that he came to the case new at the fact-finding hearing and that he'd made none of the case management decisions. She noted that the case management decisions had been made pre-HN and had not been appealed by either party, and that the mother had produced the new material late so that the father and his team had little time to process or respond to it. She accepted that it was unsurprising that objections had been made on the father's behalf. However, in allowing the appeal, she stated, and again I've set that out on the slide, that the allegations beyond those in the Scottish schedule were not either inadmissible or irrelevant, quite the opposite. She said that there will be occasions when a judge refuses to admit relevant evidence produced at the last minute before a hearing, when, for example, it's not highly significant in relation to the other evidence and/or it cannot be adduced fairly without an adjournment of the trial, which will itself cause harm and delay for the child. However, she said, in this case, not only were the allegations highly significant, but the hearing had to be adjourned in any event. The fact-finding was relisted, meaning there was time for the nature of scope of this to be considered and a further case management hearing. The mother was permitted to file a fresh statement setting out the factual matters on which she relied, including any allegations of a pattern of behaviour, to which the father was then permitted to respond with any allegations he wished to make. A pre-trial review was listed to consider what specific incidents and allegations should be determined at the fact-finding hearing, and the need for evidence from professionals and the 2 witnesses, the nanny and the maternal grandmother, was then to be considered in this context and at that hearing. The judge commented at the end of her judgment on the wider context of such cases, saying that she did not underestimate the difficulty of case management in proceedings such as this, or the significant pressure on the courts in finding sufficient time to deal with cases proportionately and fairly. She quoted from the President's guidance in the road ahead, which I quote and have put on the slide again. If the family court is to have any chance of delivering on the needs of children or adults who need protection from abuse or of their families for a timely determination of applications, there will need to be a very radical reduction in the amount of time the court affords to each hearing. Parties appearing before the court should expect the issue to be limited only to those which it is necessary to determine, to dispose of the case, and for oral evidence or oral submissions to be cut down only to that which it is necessary for the court to hear. Parties will not be allowed to litigate every issue. Now, you're probably quite rightly saying, so what now then? And that is a very good question. And the honest answer is there is no answer at present. On the one hand, we're told that we should be giving wide consideration to the issues. And on the other, we're told that judges should be taking a firm hand of case management directions and of the issues with an eye to the listings. There's been a variety of responses, and you may well be seeing courts grappling with the issue in your own cases. I have seen a variety of responses in mine. I've seen situations where the court has allowed totally unrestricted witness statements and Scott schedules with a view to reviewing those at a subsequent hearing before the further directions are given. And I've also seen a case where the court has followed the more normal pattern in the past of still directing a limited Scott schedule, but has included within that scope for a party alleging coercive and controlling behaviour to give a number of examples. In that case, it was 5 of that pattern of behaviour within the Scott schedule. So for now, I think we remain at the mercy of the courts and particular judges' willingness to engage with particular courses of action to deal with the issues that have been raised in these cases. And we wait to see what happens next, whether that may be further guidance or a practice direction. That concludes my talk on domestic abuse, and I will now hand you over to Andrew to deal with case management and court powers cases.
Good afternoon, everybody. Nicola is going to kindly deal with the slides for me today. So if there's a little lag between one and the other, then that is why, but please bear with us. So I'm going to talk to you today about some of the general case management and court powers cases that have been coming before the family courts this year. They are a range of cases, but I hope they will be of interest to you. So the first one is going to be the case of M, a child applications by email. This is a, next slide please, Nicola. Thank you very much. This is a case, in fact, in care proceedings, but my view is that it is relevant to private children cases as well, because as we all know, particularly CAFCAS, like emailing the court asking to be a Section 7 order to be varied in some way without making a formal application, and that can often lead to emails back and forwards between parties. In any event, this case was a case management appeal from a circuit judge in April 2021, and she discharged a direction for a psychological report to be prepared on the appellant mother. The case involves 4 children who were not living with the mum at the time; they were living with the grandmother. The mother herself was had very low cognitive functioning and difficulties with reading and retaining information. Understandably, the local authority issued an application to seek a psychological assessment. The judge granted that application and included within the terms of the order a provision that any application to vary this order is to be made to the allocated judge, notice to all parties, and it may be made by email to the allocated judge, provided that the party seeking the variation seeks prior agreement of the other parties and must submit a draft order. Now, it's important to note that standard draft wording is included in the the public law case management directions library precedent at 8.2 of the precedents, but not in the private children law equivalent. So it, but as I say, I think it will be relevant as we go on. Anyway, back to the narrative. Mother had missed 2 appointments for the psychological assessment, and sadly, one of those was because her grandmother had died. On the 13th of April, the children's solicitor wrote to the other parties informing them that she was instructed by the guardian to write to the court to seek the direction granting permission for the instruction to be vacated. The guardian's view was that any further delay would impact upon the timetable for the proceedings, and she could not be confident as to when the mother would respond to her solicitors. The local authority wrote to the parties informing them that the social worker had been told that the grandmother had died. So this is a very complex web of communication, sadly. Oh dear. Sorry, hang on. The Guardian solicitor wrote on the 14th of August at 3:49 to the court, the DFJ, rather than the allocated judge, not in compliance with the order, asking the court to vacate the direction for the psychological assessment. It didn't specify, for reasons that are not clear, that the mother solicitor had objected to that. About 15 minutes later, the mother's solicitors wrote to the court telling the court of the mother's bereavement and inviting the court to fix the directions appointment, but opposing the discharge of the psychological assessment. An hour later, at 5 minutes past 5, the judge vacated the direction. The judge then was asked for reasons and simply noted in a very short paragraph of about 4 lines that the appointment with the psychologist was important and that the mother had not responded, and that the judge had no confidence the mother would take part in the assessment. Understandably, the mother appealed. So this came before Lord Justice Jackson, and he drew attention to the 18.9 of the Family Procedure Rules that cites that the court may deal with an application without a hearing if A, the court does not consider that a hearing would be appropriate, or B, the parties agree to such terms in the order sought by the parties. That the parties agree to the terms of the order sought, and the court and they agree that the court could dispose of the application without the need for a hearing. Lord Justice Jackson, if ultimately allowed the appeal, and he gave some guidance on those types of cases that could be dealt with without a hearing, notwithstanding there's not necessarily an agreement. Perhaps I can have the next slide, Nicola. So this is at paragraph 34 and 44. Lord Justice Jackson said it's desirable at a time when the courts are under considerable pressure of work, where remote case management hearings have become common, for these powers to be used flexibly in the interest of justice, and in the family court in the interests of children. The court must distinguish applications that can be appropriately made without an application notice from applications that should, because of the importance of the issue or for some other reason, be made by a formal notice. He goes on to say, similarly, the court must discriminate between those applications that require a hearing and those that do not. The default position is that there should be a hearing, and as the court can only make an order without a hearing if it does not consider the hearing would be appropriate. It should be on solid ground if it makes an order without a hearing, when, as the rule contemplates, the parties agree that a hearing should not be required, or where an order is agreed. And significantly, for our purposes, it may also decide to dispense with the hearing in other circumstances, and for example, where the case is not of particular, the issue is not of particular importance, or where the proper order is obvious, or where the documents contain all the information and arguments and a hearing is unlikely to add much. There will always be other reasons why the application can be fairly dealt without a hearing. So the obviously, having cited the importance of the psychological assessment, to then discharge that without full argument and information was clearly wrong, and the judge set aside that order and they re-timetabled it. It's a cautionary tale for you and I because it requires some judgment about what is appropriate and what is not when making applications to the court, but significantly, the choice here was between ultimately an application formally made and the costs associated with that, or the costs associated with an appeal and successful one at that. And so for you and I in our private children proceedings, the court, we will need to be careful when it comes to costs and appropriateness. Thank you, Roger. The next case is A and B, which is Port Alert. This was a decision by Mr. Justice Mostyn, and the headline is it determined that the court did have the power to make a freestanding Ports Alert order. As some of you may know, a Ports Alert order is an order requiring the police and the National Border Targeting Centre to implement an all ports warning. It's usually up to a period of 28 days, which prevents the child from prevents a child's removal from the jurisdiction. It is the effective part of a prohibited steps order in the usual course of things. So the facts of this case are that a boy, Z, who was 4 years old at the time, the parties' relationship ended in the summer of 2020. The father was a UK national, mother was Slovakian, and both parents lived in South London. Z lived with his father and spent time with his mother on a supervised basis. The father applied in June 2021 for 3 orders. Next slide, please. Firstly, making a Z a ward of court. Secondly, a prohibited steps order dealing with some school funds money, and then lastly, a ports order. It was first heard without notice and then directed to be heard on notice. It's significant that this case, that it was the 3rd set of proceedings for this very young boy, which the court was not unaware of, including a cross application made in the Central Family Court rather than in the High Court, which this application had been made, obviously. Dealing with the applications, the judge dismissed the wardship. As with many cases, the court noted that this is one of the many cases in which wardship would not add anything to the invocation of the statutory jurisdiction. The father applied for a wardship order to prevent steps being unilaterally taken by the mother in relation to Z's education and medical treatment. But wardship would not add any power in relation to those issues that was not already vested in the family court under the Children Act. Wardship provides no magic solution to the father's concerns over and above what can be ordered by the family court. He also dealt very quickly with the prohibited steps order. That should be dealt with in the other proceedings, dealt with in the family court rather than the High Court. And of course, that then just leaves the port alert. Next slide, please. So he made some very clear authority on the jurisdiction for port alert. Firstly, he notes that an order for a port alert is not a substantive tipstaff order made pursuant to the inherent jurisdiction of the court. The 3 types of tipstaff orders, the passport order, the location order, and the collection order. Each of these contains as an ancillary term a port alert order. But a port alert order is not an order for the tipstaff. And he was very, very clear that the family court has no jurisdiction to grant a tipstaff order. So he goes on to describe the nature of the port staff. It's not an independent substantive form of relief. It's incidental or supplemental measure designed to give effect to the substantive order of the court and to protect a substantive claim made by the court. He cited section 31E1A of the Matrimonial and Family Proceedings Act 1984, which provides that in any proceedings in the family court, the court may make any order which could be made by the High Court if the proceedings were in the High Court. There's a civil or county court civil law equivalent as well. So that would indicate that the family court could make a port alert order, because the port alert order could be made by the High Court, but is not the exclusive jurisdiction of the High Court. The judge then went on to note that the police can make a port alert for children themselves, because it's a criminal offence to remove someone under 16 from the jurisdiction of England and Wales without everyone with parental responsibility, in aid of an injunction of breaching the criminal law, and somewhat obviously, he said, well, if the police can make a port alert, why can't the family court? Essentially, the court established that it could make a freestanding port alert order. The next slide he gives is, sorry, next slide please, Nicola. The court then went on to say how one goes about doing so. The first thing to say is the police can make an order the police can make a port alert themselves. That is in Practice Direction 12F from 4.2 to 4.8, tells you as practitioners how to do that. And effectively, it's not a court application. It is a telephone call to the police, providing them with evidence of an imminent and real threat to remove from the jurisdiction. Historically, practitioners may recall that they used to put in the court to recite that this may be a particular case for a port alert, which might help your litigant to secure a police originated port alert. But if we are making a freestanding application, the court then went on to describe how to make it. Next slide, please, Nicola. So he said he would not expect a freestanding port alert to be made by the family court routinely. Of course, you and I will know that litigants like having teeth to any order, and a piece of paper with a prohibited steps order preventing removal from the jurisdiction may in and of itself do very little, whereas a preventative port alert order would in fact give that teeth. So we are yet to see whether or not it's going to be as routine or scarce rather as the judge anticipated. But the level of evidence that is required will be clear evidence that there's a real and imminent risk to the children. And then when assessing that risk, the demand for proof is that it's more, that will not be that it's more likely than not that the children will be removed. Instead, it will be some proof of a degree of probability not far short of that standard. So not terribly clear, but certainly something more than fanciful in my, I would suggest. And certainly the court went on to say it shouldn't be flimsy or unsubstantiated. So probably something probably simply the court saying, the litigant saying, well, she told me she was, may not be sufficient unless it's backed up with some a better factual nexus. So how is the application made? Well, obviously it will be made ex parte, and it should be made to the hearing centre of the applicant's local DFJ, although it doesn't necessarily need to be made to that, but that would make sense. It is likely to be allocated to a judge of circuit judge level, or in complex cases, high court level. That probably coincides with the requirement of international elements to be heard in front of a circuit judge, but one can easily see that a district judge, certainly an experienced district judge, may be appropriate in some circumstances too, I would suggest. There is the period is going to be for 28 days. That would only be extended in an inter partes hearing. You probably have seen that there has been an update to include a ports alert order in the standard directions. There is in fact one attached to the end of the case as well, of the AB. And just as an aside, Mr. Justice Mostyn is no stranger to extending the powers of the family court. A couple of years ago, we had the case of C, H, and WH, in which Mr. Justice Mostyn confirmed that the family court has the power to order an indemnity in respect of mortgage liabilities. So we see quite an active family court jurisdiction here. Well, by that particular judge, certainly. So the next case is a follow-on in terms of injunctive relief, and that is the case of M&D, which was heard by Mr. Justice MacDonald. This is a fascinating case that dealt with the scope of the associated persons in Family Law Act proceedings for the purposes of 62.3. Very briefly, this was an application made without notice in December 2020 in front of a district judge in the Family Court in Manchester. That judge dismissed, for want of jurisdiction, the appellant's application for a non-molestation injunction under Section 42. The substance of the allegation was that the respondent had been verbally abusive, threatening, including telephone calls, social media posts, as well as in person. And the threats were pretty unpleasant. Rape, murder, and threats of acid attacks. So serious threats. The appellant, next slide please, Nicola. The appellant here was the respondent was the stepson of the appellant's sister by reason of marriage to the respondent's father, who was deceased, and so named as the step-nephew, but not the step-nephew by any sort of blood relative. So the starting point, next slide please, the starting point is Section 62, Section 62 and the associated persons, and in particular within that, this case fell under the bracket of associated persons being a relative, which is further defined in 63, and I've listed those relatives there. What you'll see is the first are all direct relatives, so it's father, mother, stepfather, stepmother, son, daughter, stepson, daughter, grandmother, grandfather, grandson, granddaughter. And the others are brother, sister, uncle, niece, nephew, first cousins, whether full blood or half blood, or by marriage or civil partnership. So the two arguments raised on appeal by the appellant were that Section 63.1a expressly includes certain types of step relatives, and accordingly the term nephew in 63.1b should be read as including step-nephew, and it would be relative meaning so as to include nephew by marriage as well. And secondly, the court should adopt a purposive construction in the context of an ever-expanding complexities of the modern family dynamics of the legitimised conception, in which different relationships and different means of legitimised conception are recognised. Simply, we're in the 21st century. And the court then reviewed, next slide please, the court then reviewed the authorities. And it's this point of the judgment that the appellant probably was pretty hopeful, because it noted the authority of Cheshire and Bashir, where Lady Sloss said had accepted the Law Commission had chosen to widen the range of applicants to include anyone who is associated with the respondent by virtue of a family relationship or something closely akin to it. And that in G and F, Mr. Justice Wall had considered that where domestic violence is concerned, the justices in that case should adapt a purposive construction and not to decline jurisdiction unless the facts are plainly incompatible of being brought within the statute. It would, he said, I think, be most unfortunate if section 62.3 was narrowly construed so as to exclude borderline cases where swift and effective protection for victims of the domestic violence is required. And of course, we can see there that this may be a borderline case. It's not slap in the middle of 63, and it's not so outside the realms of it. But the judge rejected the appeal. Having reviewed the authorities, the substantive paragraphs are at 37 and 38, and in very short terms, he said, it is, however, plain on the face of the statute that step-nephews are not expressly provided for as a category in 63(1) of the Family Law Act, in contradistinction to other step-relatives that are expressly listed in 63(1). So in short, the scope of the statute had been increased, but had been increased specifically to include particular relatives and not all step-relatives. That's me. And then at paragraph 38, he identifies the different nature of those relationships in section 63. 63(1)A deals with relationships of lineal descent. By contrast, 63(1)B deals with collateral relationships. The appellant's argument, he said, becomes one that contends that the fact that Parliament decided to include certain step relationships with respect to family relationships of lineal descent must indicate that Parliament also had intended to do so in respect of certain collateral relationships, including that of nephews and nieces. The judge said, in my judgment, the structure of the 1996 Act is apt to indicate the opposite, namely that Parliament was prepared to include certain step relationships in respect to family relationships of lineal descent, but decided not to include step relationships in respect of any of the collateral family relationships stated in 63(1)B as falling within the definition of relative for the purpose of the Act. And it's noted within the case law that in fact some other relatives of the respondent had in fact secured a non-molestation order only a couple of weeks before. However, the judge did point out that there is open to the appellant the provisions of the Protection from Harassment Act 1997 as an alternative. Of course, you and I know that costs may be more of a feature in those proceedings, but nonetheless, he would not be left without some form of relief. The next slide, please. If we can go on to the, that's the one. Thank you very much. So in improving children and family arrangements, not a case, but a new activity program by CAFCAS. Forgive me, I'm still in Peterborough Family Court, so it's the electric lights. So the new IFCA, it is a new activity programme, and the standard orders have been updated. It is a piece of short-term work, court-ordered in private law cases only, and has 4 key outcomes: reducing family barriers and resistance to agreeing arrangements, and managing any risk so that they are safe, promoting positive communication within families, ensuring children's wishes and feelings are heard and considered, and helping families agree a parenting plan to avoid future issues arising. The scope of the plan is over a few weeks, may include but not limited to meeting the parents together individually to help resolve the issues, direct work with the children to prepare them, and observation of the adult spending time with the children. Significantly, a proposed work plan setting out the agreed work to be undertaken will be settled, and that observation may be done in a contact centre, could be done at home or the community or other suitable setting. It's funded, as you might expect, by CAFCAS, but is provided by subcontractors. For the Surrey, Sussex, Greater London, Kent, Hampshire, Isle of Wight and Dorset areas, is going to be by the by Swan Family, but then there is subcontractors, so don't be alarmed if you get someone else. What the difference between the CCI, its predecessor, and the ICFA are? Well, the CCI was much more focused on on short-term intervention by supervised contact. The ICFA doesn't place the same emphasis on the supervision of contact, but rather helping parties agree safe contact arrangements. Very significantly, the ICFA is much more flexible and much more tailor-made to the individual family's needs. It's less prescriptive in how it might achieve its goals, which for some people are going to be much more important. At the end, as you might expect, there's a report for the courts. My experience of this course is that the courts consider it a resource-intense proposal, and so the court you're going to have to think imaginatively if it doesn't work in re-establishing contact and explore the reasons why. In my last few moments, I'm just going to deal with a very recent edition of the by the President. On the 4th of October, he sent out the President's Memorandum on Instruction of Experts. This is, in effect, a reminder to everybody about what to look out for when you're considering the experts. It's a very short document, very helpful to read, particularly if you're looking to oppose an expert or looking to instruct one and selecting one. In terms of, he reminded us that the 4 criteria for governing the admissibility of opinion evidence is whether the proposed expert evidence will assist the court, whether the witnesses have the necessary knowledge and experience, whether the witness is impartial, and whether there is a reliable body of evidence or experience to underpin the court's underpin the expert's evidence. All of those really are self-explanatory. It's worth noting the latter one of those, number 4, in which the court said the President said that there's more difficulty whether the science or body of knowledge is not widely recognised, and the court will refuse to authorise or admit the evidence of an expert whose methodology is not based on a substantial body of knowledge. In effect, it's a significant warning to avoid pseudoscience. And then, as all good family lawyers know, you've still got to overcome the hurdle of necessity. When you're considering necessity, obviously we've got FPR 2543 and Section 13(6) of the Children's and Family Act. It will only be necessary where it's demanded by the contested issues rather than having been merely reasonable, desirable, or of assistance. It is a higher threshold than the standard of assisting the court as set out in the first of those 4 previous proposals. And the President noted the instructions of experts is the primary reason for delay in family court proceedings relating to children. And of course, that is an even more pressing reality nowadays. It does, in fact, help. Very lastly, it does in fact bring home some of the provisions of FPR 25B, which sets out the requirements of the expert to comply with certain standards. That is well worth reading, particularly 4.1b, which sets out what's actually required, because you may fall foul of it when you're considering psychologists and psychiatrists expert, and in particular that they are in possession of current license, are up to date with CPD, and have received appropriate training on the role of an expert in the family court. That sometimes trips people up. There is at the end a list of other cases that Nicola and I found were interesting, dealing with some tangential matters. Please do have a read of those. We would highly recommend them. I think there's an email address, but please feel free to email either Nicola or myself if you have any questions. We're very happy to answer them, or clarification, or if we can assist at all. It was very nice having you all. A recording hopefully will be made available, and no doubt Gavin and the clerks will help out with that. Thank you very much.